High Court of Australia is now in session. Please be seated.
Call the matter for hearing.
Pandey and Roebuck City Council.
Yes, could you announce your appearances, please?
May it please the court. My name is Mr. Martyn, and I appear alongside my learned junior, Ms. Perry, for the appellant in this matter.
Thank you.
I will be speaking for 21 minutes and my learned junior for a further 18 minutes. We reserve 1 minute for reply. May it please the court.
Your Honours, may it please this court. My name is Neo, spelled N-E-O. Appearing alongside me is Mr. Pandey, spelled P-A-N-D-E-Y, and Mr. Chong, spelled C-H-O-N-G. Together, we appear on behalf of the respondent, the Roebuck City Council. With this court's permission, Mr. Pandey and I will be speaking for 19 minutes each. May it please this court.
Thank you. Yes.
May it please the court. This case concerns the respondent council who exacted monies under an invalid resolution. Despite the appellant's initial protest and subsequent discovery of the resolution's invalidity, the outstanding amount has not been repaid.
You can assume that we've read the facts. You can assume we've read each submission. So unless you're getting to a particular emphasis on a particular aspect of the facts in support of some proposition, don't bother.
Certainly, Your Honour. And to that effect, I will make two submissions. First, I'll address the applicability of the 1993 case of Woolwich Equitable Building Society and Inland Revenue Commissioners into Australian law. And second, in the alternative, I will address the claim for duress colore officii. If Your Honours are with us on one of these, you should grant this aspect of the appeal. My learned junior will then address the applicable defences.
Are we allowing or disallowing appeal or just answering questions?
We submit, Your Honour, that this is an appeal for the restitution to be made, and therefore we are answering those questions to that effect. We seek the relief that the outstanding amount be repaid and costs be awarded accordingly. I now turn to our first submission. First, we submit that the primary judge and Court of Appeal were correct to find that the principle outlined in Woolwich should be incorporated into Australian law. And there are two reasons for this. First, Woolwich is consistent with Australia's analogical mode of legal reasoning to develop new heads of recovery. And second, Woolwich is supported by constitutional considerations. Turning now to the first of these two elements. We agree with our learned friends that in Australia, heads of recovery are developed by analogy to existing heads of recovery. And this was held by Justice Gummow in the 2001 decision of this court of Roxburgh and Rothmans of Pall Mall at paragraph 72, where His Honour noted that this is how heads of recovery develop. And moreover, in the case of British American Tobacco of this court, the court noted there at paragraph 39 that the categories for these heads of recovery are not closed. We therefore seek to rely on two heads of recovery to analogize the Woolwich principle from. The first being failure of consideration, and the second being duress colore officii.
But is it really enough that you can say there's an analogy, or shouldn't you need to focus on why it's necessary to introduce this thing?
Yes, Your Honour. And we submit that the reason it is necessary is this goes to the principle that the House of Lords noted in Woolwich of no taxation without authority, which forms part of the common law, but is yet to be readily recognised under these heads of recovery currently existing. And to that effect, that is where we draw this analogy.
Why is it important to recognise that?
This is because...
Put it this way. We know that in this area of discourse, there's a right to recover for monies paid under a mistake of fact or law. Now we have law. They didn't have law in Woolwich. And we know that there's an ability to recover monies exacted under a demand under colour of office. So what's the gap? Why is it necessary to give this other remedy?
The gap, Your Honour, I'll answer Your Honour's question in two parts. So similar in Woolwich, there is a situation which has occurred in this case where none of those heads of recovery might be applicable. And the reason why is the plaintiff may not be labouring under a mistake of law, there might not be duress calore officii, or there might not be a full contemplation of a failure of basis or consideration. And therefore, Woolwich fills this lacuna within the law. And to provide an example with the first head of recovery of failure of consideration, we submit that in Woolwich, the House of Lords engaged in a discussion of why failure of consideration could form an analogy with the Woolwich principle. And this was also noted by Justice Gummow in Roxburgh at paragraph 104, where His Honour noted that the failure of consideration claim occurs when the entire basis for a payment fails to sustain itself. Indeed, Chief Justice Mason, in the case of Royal Insurance of this court, also noted that the legitimate basis failing for a payment could ground a case for recovery. And to then turn to Your Honour's question about what gap this fills in the law, we submit that presently within law, there are certain circumstances where failure of consideration would be precluded by an operation of defence, whereas Woolwich has an express different normative basis to failure of consideration, in that it...
Martyn, are you suggesting that if there was no legal basis for the demand, that there would automatically be a failure of consideration?
We submit that is certainly quite so, Your Honour, that if there is a complete failure of the lawful requirement for the demand to be lawful and then make the repayment, as there was in this case, there is a total failure of that consideration. But what Woolwich adds is it recognises that states or public authorities have a monopoly over legitimate coercive power. And this is important because that then informs the operation of defences. For example, in the United Kingdom, the 2014 English High Court of England and Wales case held in FIR test claimants that the defence of a change of position cannot apply to a Woolwich claim because it would stultify the rationale for Woolwich. And therefore, that is what Woolwich adds to the existing failure basis head of recovery. We furthermore submit that, on this note, the Woolwich principle can be analogised as well with duress calore officii. In the House of Lords decision, the three majority lords of Lord Gough, Lord Brown-Wilkinson and Lord Slynn all engaged in a discussion of calore officii with analogy to Woolwich, drawing on the 1959 decision of this court of Mason and New South Wales. What their honours relied upon was the fact that calore officii recognises the inherent power imbalance between a public authority and a non-public actor. And it is to this effect that Lord Slynn, at page 204, noted that whilst the Woolwich claim does not fit neatly into a claim for duress calore officii, it shades into it. And to that effect, this is where we draw the analogy with duress calore officii.
Why wouldn't the better course then, in a legal policy sense, be to shade the elements that might otherwise be an obstacle for recovery, namely the demand having to be, I won't do my public duty unless you pay? Why wouldn't that be the better course to respond rather than recognising this distinct new course of action?
We submit, Your Honour, that the difference between Woolwich and calore officii is calore officii looks to the quality or vitiation of consent by the payer, whereas Woolwich only requires there to be an ultra vires demand to give restitution. And that is the normative distinction we submit is important here. Indeed, the case of Woolwich itself wasn't found on calore officii because of this very fact.
Would it be possible then to consent to payment for an unlawfully demanded sum?
As my learned friend, as my learned junior will later address, we submit that it is not possible to consent to if one is acting under compulsion. And in any case, that is where we would draw the line in this case, Your Honour. If I could then, to tie off this submission, take Your Honours to tab 1 of the appellant's bundle of authorities at page 198. and it's next to the letter H down the bottom of the page. This is the judgment of Lord Brown Wilkinson, where after having discussed both these heads of recovery, being failure of consideration and duress calore officii, his lordship notes that there are, therefore, in my judgment, reasons by way of analogy for establishing the law in the sense with which Lord Gough provides. And we submit that these provide an indication as to how this court can develop the Woolwich principle by analogy to those heads of recovery.
Seems strange, though, that you would say they're analogous, but actually have different normative bases.
We submit, Your Honour, that all we are trying to do in this case is analogize in the sense that they are similar, but they do not need to fall distinctly within. So although the normative bases slightly differ, we submit that the elements that, say in failure of basis, the consideration or underlying rationale for the payment fails, and in duress calore officii, there is the illegitimate power or the illegitimate sense of power between the parties, is where we draw that analogy.
But when you say underlying failure of consideration, what's the consideration for the payment?
In this case, Your Honour, we state that the consideration is the contemplation that the exaction was lawfully required, and that totally failed here because it was invalid. If Your Honours have no further questions on this part of the submission, I'll now turn to the second, which are the constitutional considerations pertaining and supporting Woolwich. We submit that in Woolwich, the principle of no taxation without authority that Lord Gough relied upon from the 1688 Imperial Bill of Rights forms part of the Australian common law. And this is noted by Chief Justice Mason in Royal Insurance at page 69. It is at this point, however, that I would like to turn the court's attention and address what our learned friends have put to this court as to why constitutional considerations do not favour adopting Woolwich. The first point that our learned friends put to this court is one of fiscal chaos, relying predominantly on the Canadian Supreme Court case of Air Canada. However, we would respectfully distinguish that case on two reasons. First,
is fiscal chaos just a floodgates argument?
we submit, Your Honour, that it is not, in the sense that fiscal chaos is the concern that by awarding a Woolwich-style principle, it could bring a claim or could bring the circumstances where the government is in terms of fiscal chaos of spending monies that it has exacted, because it would have to pay it back to the plaintiffs, but then would presumably then try and get it back.
Or more than that, the invalidity of the law may not be known for many years.
Yes, Your Honour.
And that then all of a sudden it comes to light, the consequence being that whoever's collecting the invalid fee will there'll be a huge claim on the revenue.
That is so, Your Honour. However, the important thing that both the subsequent decision of King Street and New Brunswick and Chief Justice Mason in Royal Insurance noted at page 68 is that those considerations are not to be considered in a fiscal chaos sense as a defence to Woolwich, and that is because it would effectively go the other way and allow public authorities to spend themselves into power. And this goes against the common law principle of no taxation without authority. The second point that my learned friends rely upon for this fiscal chaos is the 2013 case of Thiessen the Collector of Customs. However, that case only particularly pertains to section 167 of the Customs Act.
So I'm just not sure how this argument meets the point. If we're talking about the development in the law for which there's presently no acceptance by this court, the possibility of the risk that my colleague Justice Derrington has mentioned is a particular issue. Now you can say, oh, that's against some lovely principle of common law, but why? It doesn't negate it. It doesn't answer it in any way whatsoever. Why isn't it a problem?
We submit it is a problem, Your Honour, because the consequence of allowing a fiscal chaos defence would effectively allow public authorities to spend themselves into power. The idea that...
But do they do that now?
We submit that if they do that now, then there is a right to restitution for that, and they shouldn't be allowed to in any case. And therefore, the fiscal chaos considerations are not a strong defence to this claim.
Sorry, no. We're talking about the elements of this new cause of action, which you say should be recognised And one problem that is suggested to exist is that if you do recognise this, you will create an easier cause of action against governments, which could have the problem that is referred to in the cases as fiscal chaos. Now, what's the answer to that problem? If it's a real problem, why should we recognise this cause of action? What's the real answer to it?
The answer is that is an issue for the legislature, Your Honour, not for the law of restitution to develop and accommodate this.
Well, it won't be, will it? If we're talking federal, because you've got to give proper recompense to property rights if you take them. So if you find there's this valid cause of action for a bucket of money, and you say, holy dooly, we can't pay that. I know what we'll do. We'll follow WA and we'll extinguish that cause of action. Well, you can't do it in the Commonwealth.
Yes, that is so, Your Honour, but the ultimate principle of fiscal chaos that we rely upon is that it cannot find this ground, ultimately because the government would therefore never have to act within their powers. They could merely make an exaction and therefore spend the monies however they like.
So you say, well, it's just too bad. If it happens, the governments will just have to pay it back. But this will, perhaps the answer is the recognition will have a salutary effect on governments being careful to exact things properly.
Yes, that's exactly the case, Your Honour.
Did you want to say something?
Relying on...
Or a limitation period can be that.
Particularly so, Your Honour, yes. Moreover, as Chief Justice Nathan has noted in Royal Insurance, at page 69, it would be subversive of this common law principle of no taxation without authority to allow public authorities to therefore exact money and spend it in that way. And it is also akin to the 1924 case of Auckland Harbour, which was recently affirmed in Sims in the Commonwealth, a 2022 New South Wales Court of Appeal case, that there is a prima facie right to restitution when monies are paid out of consolidated revenue. And therefore, as the learned authors Martyn and Carter argue, the same is in the reverse, namely if monies are paid in, they ought to be ultra vires, there ought to be a prima facie right to ultra vires have them paid out. To then tie off this submission, we note that Woolwich has received support by lower court decisions, particularly in the recent federal court case in Prigodish and the Commonwealth, and therefore we submit that Woolwich should form part of Australian law. If Your Honours have no further questions on this submission, I'll now turn to the second of duress colore officii.
Sorry, you say in relation footnote, is it footnote 20? The weight of authority favours the adoption of Woolwich in Australia, and you footnote the Queensland Court of Appeal case of Redland, which simply does not support it.
We know,
simply says the High Court hasn't dealt with it.
we know that so, Your Honour. However, if I can bring your attention to Prigodish as another case.
I've read that.
Yeah.
Prigodish says there's no reason why not. But I'm just interested in why you've cited Redland as a case that's supportive of the proposition in the footnote. It seems to be wrong.
We submit that whilst Redlands provides no account for favourite, for and against, that issue is presently before this court, and that is later to be decided that way.
My question is the correctness of including Redland in footnote 20.
We submit that we've merely included that as a proposition to support and note that this is an issue before the court.
So when somebody says the weight of authority favours this, see these cases in a footnote, and one of them simply doesn't, do you think that's a correct footnote?
No, Your Honour, and if I may depart from that aspect of written submissions, that is what we'll do. Turning now to the second element of this, or second aspect of this submission, we submit that alternatively, a claim for duress colore officii can be made out. Historically, the requirement for an express threat made sense when colore officii was confined to cases of extortion for the fulfilment of a statutory duty. However, in the 1959 case of Mason, that was shed because the case there concerned the power to grant a licence rather than a statutory duty to do so. In this submission, we draw two distinctions. The first is that a more liberal view from Mason, from mere threat of or the mere presence of an unlawful threat or act, or if I may rephrase, an unlawful provision is enough to amount to duress colore ficii, and alternatively, the option of an unlawful provision plus the belief of enforcement is also enough.
Well, I mean, it's not a big step to think that when somebody is met with a demand, not just a piece of correspondence saying, please pay me this, but is met with the equivalent of a rates notice, that you don't need anything more, because wouldn't an ordinary citizen think, well, it's like a tax assessment. I've got to pay this, otherwise I'm in a fight with the government.
Yes, Your Honour, and that's exactly what we rely upon. In the decision of Mason itself, Justice Kitto at page 129 found that the threat or an unlawful threat is quite enough to amount to compulsion. And that is precisely what we have here. We have an unlawful demand, given the resolution was subsequently invalid, and therefore, if Your Honours are with us on that ground, that is quite enough compulsion to establish duress colore ficii. In the alternative, if Your Honours favour a more restrictive view, we also submit there is the danger of enforcement that follows from this. The majority of judgments in Mason, being the judgment of Justice Kitto, Chief Justice Dixon at page 117, Justice Menzies from pages 134 to 5, and Justice Windia, who delivered what is being considered the leading judgment at paragraph 146, all note that reasonable apprehension of penalty or compulsion under the Act is enough to establish duress colore ficii.
Why would you need, is that what you say, saying that's what the majority say?
Yes.
I find that a curious proposition. No doubt your opponents will have to answer what I'm saying to you now, but the ordinary assumption would be that there's a statute that backs the exercise of power, and if a formal request for payment is made, that it's not optional. There'll be a statutory power to sue for a debt established in a particular way. You don't need threats or anything like that. That's just what happens.
That is, we most certainly agree with that, Your Honour. And this submission is merely to address what we believe our learned friends will state, which is that they do need such a threat or something more. And we submit that in this case, the combination of there being a ruthless litigator, and Your Honour, may I just request a 30-second extension to finish my submissions? Thank you. The combination of the council being a ruthless litigator who gets their money one way or another, and as Your Honour has suggested, the danger of charges, liens or other statutory provisions placing compulsion or a danger to the plaintiff's property is more than enough to establish duress colore ficii. And if Your Honours have no further questions, that concludes my submissions. May it please the court.
May it please the court. Your Honours have heard from my learned senior on the appellant's prima facie right to recovery. We further submit that the appellant is not precluded from recovery due to the two defences pleaded by the respondent, namely first, the defence of voluntary submission to an honest claim, and second, the defence of good consideration. We note that the respondent bears the burden of proof to establish these defences. Turning to my first submission, namely that the respondent does not have a total defence of voluntary submission to an honest claim. There are two limbs to this submission. First, as a matter of law, the defence is not available in the context of ultra vires exactions. And
if we accept the Woolwich principle.
Yes, Your Honours, we note at this stage of the inquiry, we're proceeding on the assumption that there is a prima facie right to recovery under the Woolwich principle, or in the alternative, the colore ficii principle. And our second limb of our submission is that the defence is not made out on the facts. As to the first limb, we submit the defence is not available for two reasons. And the first is that voluntary submission is not a freestanding defence, but negatives an action of the prima facie cause of action itself. and second, it should not apply to preclude recovery of payments made pursuant to ultra vires demands. First, my learned friends in their written submissions cite the definition of voluntariness in the 1992 decision of this court in David Securities at page 373, namely that a payment is voluntary where the payer either believes the payment is invalid, is not concerned to query its validity, or is prepared to make the payment irrespective of its validity. We note this discussion in David Securities was made in the context of early cases on mistake of law, and this broad definition of voluntariness operating to preclude any situation where the payer entertains doubts about the validity and pays anyway, operates in mistake of law cases to negative the existence or causative nature of a mistaken belief.
But it's a good principle because it brings finality to transactions. If someone receives a demand from another party, they're concerned, but they figure that lemon's not worth the squeeze, they then will happily they pay up and move on. Why should they be able to revert and try and contest then what they're prepared to pay?
Your Honour, we accept that principles of finality of disputes have been used in discussing generally voluntary payments. For example, as cited by my learned friends Edelman and Bant, state that the defence would operate where a defendant submits to the plaintiff's claim that has been formally commenced in the courts. And we accept in that context, rather than merely just a threat of litigation, where a claim has been commenced and a payer compromises or settles that claim voluntarily, the principle of finality of disputes would operate there.
I think the question was directed to why should the same notion that does apply for mistake cases not apply for the Woolwich principle acceptance case? Why is the notions of finality not relevant in such cases?
Your Honour, we submit that the definition in David Security as to voluntariness, which was motivated by a desire to preserve the finality of disputes. And we note that in David Securities, the justification was to preserve the finality of bargains and compromises freely entered into. Here we submit bargains and compromises involve notions of consent, which are not present under a Woolwich claim, where the prima facie right to recovery arises merely because a payment was made pursuant to an ultra vires demand. This claim does not involve any inquiry into the plaintiff's subjective state of mind, and any inquiry into the voluntariness of the payment or whether the payer adopted the risk as submitted by my learned friends is therefore a foreign inquiry. We note that my learned friend also
That might be a reason. I know this isn't the subject matter of your address, but the aspect of finality might play into notions of fiscal chaos and be a reason why we would not accept the Woolwich principle and would leave recovery in these sort of fact scenarios with mistake and demands colore officio.
I accept Your Honour's concerns about the possibility that this may lead to a floodgate of demands against public authorities in terms of the fiscal chaos concerns. However, we submit there is already a natural limit in terms of protecting finality of disputes, and this is due to the pre-existing operation of principles such as estoppel or election or merely contractual agreements to settle or compromise a claim, and therefore we submit that this principle of finality of disputes is dealt with sufficiently based on these principles already. We note my learned friends also rely on the concept of risk-taking in justifying this defence and refer to the discussion of Edelman and Bant that states that permitting restitution where a payer has made the choice to pay rather than to litigate involves transferring the risk of invalidity of the demand to the payee. We submit in the context of ultra vires demands, where there is a public authority and a citizen, it is appropriate that the burden of determining the validity of payment falls on that public authority, as opposed to requiring every taxpayer and ratepayer to make their own inquiries as to the validity of demands before paying.
But that same inequality arises in every case where one side makes a demand. One party can put on the onus, put the onus on that other party by simply demanding the payment be made, and then it's up to that party to decide whether to pay or fight.
Your Honour, we submit that in the context where there is a public authority and a citizen, the very nature of that unbalanced relationship, including the fact that the public authority has legitimate coercive power over a citizen, means that it should be incumbent on a public authority to ensure that the charges and taxes they are levying accord with the formal requirements under statute, and that they are making legitimate demands.
Well, I don't see that the power asymmetry actually has anything to do with whether a party fights or not. You can either pay up or not. The mere fact that it's a council seeking the payment as opposed to another party to a contract doesn't seem to me to make any difference to the principle. But
Your Honour, if I could give an example of how that may make a difference for a payer and choosing whether to litigate or not, I can draw Your Honour's attention to the cases, to the facts in Woolwich, where the building society in that case chose to pay first and then contest later because it wanted to protect its reputation and not be seen as an organisation that does not pay its taxes. And therefore we submit that the position of a public authority demanding levies from its citizens is different to normal commercial transactions where a demand is made.
I suppose there might be some merit in the proposition if you're talking about, well, alteration of where the balance of risk lies. I think that's probably another way of translating the point earlier made about the constitutional basis and the fundamental principle of public law, probably a reflection of that, to the extent that that risk aspect influences our thinking.
Yes, Your Honour, we agree that it would promote good administration if we ensure that the responsibility is on public authorities to ensure that their demands are valid.
Does it matter whether the Woolwich principle is a constitutional principle or one that is based on higher notions of duress, based upon the power of the state, as to whether your argument about the effect of an expression of consent to a demand has an effect or not? It struck me that your argument earlier on was that we should allow Woolwich claims because they're really a different sort of duress claim, but just a higher form of duress claim, where the duress is implicit in the power of the state. Is it not possible for me to consent to pressure in the private law? And if it is possible for me to consent to pressure and pay in the face of pressure without consequence, why should it be different where I pay to government if the basis of recovery against government is some sort of pressure?
Your Honour, we submit in respect to consenting to pressure. In that case, the Cholera Fiki claim would not be made out because it needs to be shown that any duress is causative of payment. If a payer is intending to consent to the payment, it would not be so causative. We submit that on these principles, they do not rely on taking some constitutional principle and translating it into a private law cause of action. Instead, we merely state that these common law principles of no taxation without authority go to the court's determination in whether such a defence should be applied to these facts.
Yeah, but I think the point, I understood my colleague's question to you was directed to the more general proposition of principle concerning Woolwich, that Woolwich maybe is really just another variant of Cholera Fiki. So if it was, then the distinction that voluntariness is not a defence, you know, why is that distinction still extant if it really is just a different nature of it?
Your Honour, we submit relying on my learned senior's submission, that the reason that we rely on Woolwich as distinct from duress cholerae officii is due to these normative basis that underlies Woolwich, whereas cholerae officii is concerned with the quality of consent to a transaction. Due to these policy reasons in Woolwich, we rely on the 2014 England and Wales High Court case of FAA claimants.
I think the problem with that is that which you characterise as the normative aspects is another way of characterising what was just said to you by my colleague, namely, isn't it really just a stronger public law demanding person? Why is it different?
Your Honour, we submit that it is appropriate for this court to develop private law principles in addition, in coherence with constitutional considerations as well. And therefore, we submit that this does not pose any bar to this court deciding that there is different principles at play where there is an ultra vires demand.
If this was demanded by constitutional principle, would courts have the capacity to make any variation at all? Any cutbacks on its operation? Common law? Would it even be open to courts or legislatures to restrict the range of rights that might be available to people who paid in consequence of an ultra vires demand?
Your Honour, could you please repeat your question?
Well, if the principle is inspired by the Constitution, and presumably the Constitution has something to say about whether legislatures can cut back on it.
Mm-hmm.
So would the Constitution then potentially invalidate any legislation that was put into effect to try to deal with the consequences of fiscal chaos to which my colleagues earlier referred?
Your Honour, we rely on not a specific constitutional prohibition, but rather the constitutional considerations that exist in the common law as opposed to the written text of the Constitution.
Public law rather than technical constitutional law. You're not saying an implied constraint that derives from the Constitution of Australia.
Your Honour, if I could put it another way, we're relying on small c constitutional principles as opposed to big C. Turning...
Can I just ask you, why do you need to rely upon this when the facts are on your side in this case?
Your Honour, if I can move now to the facts.
No voluntary submission because your client always paid under protest.
Yes, Your Honour, and turning...
Don't you win on that?
Yes, in the alternative, we submit that on the facts, this defence isn't made out. And this is because the appellant's payment at paragraph 3 is not consistent with voluntary submission or paying to put an end to the matter, as my learned friends put it in their submissions. This is due to two facts at paragraph 3, which Your Honour mentioned. The first is the protest, and second, it is the fact that the appellant stated that it is easier in the short term simply to pay up. This is therefore not consistent with an intention to close the transaction permanently.
It's always easier in the short term to pay up if you can afford to. It's hard to litigate. It costs buckets of money and time and effort. So I'm not sure, why does it being easier have anything to do with it?
Your Honour, we submit that it is the words in the short term that we rely on, in that he's not planning to close a transaction permanently and never intends to contest it. And with this, we rely on both these words and the nature of the protest in combination in submitting that there was no voluntary submission.
You pay up a demand from a local authority and say, I'm paying this under protest, as appears to have said, and it's unlawful. It can't ever be a voluntary. I mean, that takes away any voluntary submission to a claim, doesn't it?
Yes, Your Honour.
The main point. Anyway, sorry.
I'm just wondering why the subjectivity in the short term is at all relevant to this question.
Your Honour, the words...
My colleague is just saying, well, it's in the words. It's accompanying the payments. That's the thing. Whether he's thought personally, oh, this is just a short-term thing, I'll sue them later. How can that be relevant?
Your Honour, we submit it goes to the fact that voluntary submission does concern whether the payment is made with the intention to close a transaction permanently.
But
and
the
that,
subjective intention, not the intention assessed objectively.
Your Honour, we accept your concerns on this point and we rely primarily on the protest.
I'm concerned with the only concern I have is what the law suggests. And your answer suggested that one was assessing this by reference to the subjective state of mind. And I'm surprised at that. If that is the law, I thought the law would more likely be an objective assessment of the voluntariness or otherwise. But what's the answer? What does the law say?
Your Honour, the law does not expressly say whether voluntary submission is assessed subjectively or objectively. We accept, even on the objective view of this, this assessment, that this is said to his wife, and therefore he expressed these beliefs when he made the payment, and it's not just merely existing in his mind at this time. If I could turn briefly to the defence of good consideration, Your Honours, we submit this is not available in the context of wrongfully exacted imposts, because the cases in which this defence has been accepted are those where there is a consensual bargain between the parties, such as the case of Ovidio Carrillo and Dog Depot, and the case of Adrenaline and Bathurst Regional Council. The existence of a bargain is important because while consideration in this context does not have the same meaning as contractual consideration, it does entail the ability of the two parties to freely negotiate the subject matter of their relationship.
But isn't there a case directly on point, on this very point, about consideration that you haven't relied on?
Your Honour, if there's a specific case you have in...
Those judgment in Revon City Council, doesn't he specifically address this and specifically say things that favour your side's argument?
Yes, indeed, Your Honour, but we do note that this case is awaiting appeal in the High Court.
It hasn't been determined yet.
Yes, and we do note that the comments in that case are favourable in this context because it involved very similar facts. In respect to the consideration side in that case and defining consideration, we accept it was different in that case because it operates on a mistake of law basis, that the ratepayers in that case were mistaken as to whether it was valid. Here we accept there was no mistake of law. However, we submit that given consideration means the state of affairs contemplated as the basis or reason for payment.
So, in other words, is there any difference in logic of the argument that you apply here from the argument that Justice McMurdo expressed in Revon City Council in relation to consideration?
Your Honour, has my time expired? May I request just a minute to answer your question and finish off? There is a difference in logic in terms of the justice in the Redlands City Council and COSIC submissions identified that the relevant consideration was the payer's belief that the demand was valid, which it wasn't. Here we submit that the relevant consideration was to stay the council's hand due to the fact he believed they would get their money one way or another, and was not in fact the value of the drainage works, given he did not believe that these were a useful use of the council's money and resources. If there are no further questions, Your Honours, that concludes the appellant's submissions.
Thank you. Yes. Yes.
Your Honours, may it please this court. As earlier introduced, my name is Neil. I'll be addressing this court on the first and second issues concerning the grounds of restitution available to Mr. Camden. Thereafter, Mr. Pandey will be addressing this court on the third and fourth issues concerning the defences available to our client. I'll be making the submission that there are no grounds of restitution available to Mr. Camden, not on the ground of the Woolwich Rule, and not on the ground of the doctrine of money paid under the colour of the office. If this court were to find in favour of Mr. Camden on either of these issues, Mr. Pandey will then thereafter go on to show why this court should still decide in my client's favor because there are defenses available to my client. I'll turn first to the issue of the Woolwich Rule. Now, the starting point of my argument is that the Woolwich Rule does not represent a principled development in the law of unjust enrichment. And the reason for this is because it is inconsistent with the Australian legal approach towards developing case law. As has been recognized by my learned friends, the Australian legal approach requires the courts to take an incremental approach towards developing the law. That means drawing principle from precedent and reasoning by analogy. And this was the approach identified by this court in the decision of Roxburgh and the Roxmans of Palmer, Australia. The reason that I say that the Woolwich Rule is inconsistent with this approach is because it was not reasoned by analogy to any of the existing unjust factors in the law of unjust enrichment. Now, earlier, my learned friends referred to two existing unjust factors to which the Woolwich Rule can be reasoned from. These are the failure of consideration factors and the doctrine of money paid under the colour of the office. Now, Your Honours, on one hand, my learned friends have referred to these unjust factors as being analogous to the Woolwich Rule. But on the other hand, they make the claim that the normative basis of these unjust factors are different from the Woolwich Rule. Your Honours, we say that this difference is not just small, as my learned friends have submitted, but they are significant. The Woolwich Rule is a policy-motivated factor, while the
choice about a normative proposition.
Your Honour, apologies.
You say that if the difference is normative factors, then the choice in favour of it is a particular evaluation of normative factors. It's just making a policy choice. Is that the proposition?
Well, we say that making a policy choice might be possible. Allow me to rephrase, Your Honour. We say that it would be dangerous for this court to simply recognize policy-motivated factors because it would simply reduce the law of unjust enrichment into a normative principles, because any ground of restitution may be easily made to a policy-based factor. We say that this is inconsistent with an approach that requires reasoning by analogy. Now, the factors that my learned friends have referred to are the doctrines of money paid under the colour of the office and failure of consideration. These doctrines are concerned with the finding of a vitiating factor that demonstrates a defective donative intent on the part of the plaintiff. Now, Your Honours, in the case of Woolwich, there was no discussion of such a finding of a vitiating factor. In fact,
Pause you there. So Lord Gough does refer, of course, to the constitutional background as the basis of his principle, doesn't he? He probably talks more about the constitutional principle and the Bill of Rights than anybody else in that case. But he also says that when the revenue makes a demand for tax, the demand is implicitly backed by the coercive powers of the state and may well entail, as in the present case, unpleasant economic and social consequences. So it's not clear to me exactly what it was that Lord Gough was taking as the inspiration for the principle that has come to be known as the principle in Woolwich, but it certainly wasn't only, was it, the Bill of Rights?
well, Your Honour, the passage that Your Honour is referring to in relation to Lord Gough's discussion seems to be a discussion of the doctrine of money paid under the colour of the office. And this doctrine requires an assessment of the compulsion of the plaintiff, and that is where the defective donative intent is present.
The passage follows a statement that common justice seems to require tax to be repaid. And it actually precedes the passage in which he goes on to discuss the Bill of Rights.
Yes, Your Honour, the difficulty with that passage is the precise reference to common justice. As this court has noted, the law of unjust enrichment should not develop on the basis of vague notions like common justice. And the reason for that is because it would reduce, once again, the law of unjust enrichment into a normative principle where restitution can be grounded on simply any circumstances that this court finds unjust.
So you're saying he's making it up?
I will not go so far to say that, Your Honour. But we say that
I'm not sure that you shouldn't. I'm not sure that it's wrong for you to say that. You're not, because consistently with your argument, you say that proceeding in the analogous way by increments that courts of common law should proceed is not proceeding by making a normative statement of a level of generality that is not actually supported by existing case law. That's actually reasoning in the opposite way. Making it up might be a bit pejorative, but the conception that you're advancing is that you're starting with the proposition that this can't be right, and then you're reasoning from that, and you're criticising that as an inappropriate way of reasoning.
Yes, we say that that would be a top-down approach that was adopted by Lord Gough in that case. And in fact, Your Honour, I would go so far to submit that Lord Gough was cognizant of that he was taking an approach that was inconsistent with the incremental approach. In that case, Lord Gough framed the question as one of whether, despite the authorities, the Lordship's House should reformulate the law. The phrase reformulate, Your Honours, goes so far to show that Lord Gough was aware that this was not an incremental reasoning, but a top-down approach. And in fact, Lord Keith similarly, in his dissenting judgment, criticized the recognition of the Woolwich Rule as one which would amount to a far-reaching exercise of judicial legislation. To make good this point, Your Honours, we say that the danger of judicial legislation is far more pronounced because of the implications of recognizing the Woolwich Rule. These implications, as alluded by my learned friends earlier, is the potential of disrupting public finances. This risk of recognizing a general rule permitting the recovery of taxes has been recognized by various apex courts around the world, including the House of Lords, including the Canadian Supreme Court, and including this court.
But a problem for that argument is it's been 30 years in Britain since Woolwich. And although one might say that society has some difficulties, I'm not sure that one can connect them up with the acceptance of the Woolwich principle.
Well, Your Honour, it is true, as Your Honour says, that in Britain, there has been no evidence or no proof of fiscal disruption by result of the recognition of the Woolwich Rule. But I would say that absence of proof does not always amount to proof of absence, Your Honour. And Your Honour, my case today does not rest on the proposition that if we were to recognize the Woolwich Rule today, Australia, yes, Your Honour.
You also have a very different system of governance in the United Kingdom, whereas Australia has larger, more robust governments in states and federal government. So that may be the difference. And it's not an unusual thing to see local council rates being upset in the law courts. It's a regular thing that happens. So it may be we just don't see the evidence of the consequences of upsetting.
Yes, Your Honour, we absolutely agree that there's been no evidence so far. But as Your Honour earlier mentioned in relation to my learned friend's submissions, the invalidity of laws may not be discovered for a very long time. And it might be that there might be invalid laws floating around England and Australia that might cause this disruption. And Your Honours, my case today does not rest on the proposition that if we were to recognize the Woolwich Rule today, Australia would be in fiscal chaos tomorrow. Simply that there is a prospect, and that prospect makes the exercise of judicial legislation much more dangerous, and we would say that this exercise might be better deferred to the Parliament, which has the stronger institutional competence to make this decision.
Well, if it has the competence to make the decision, presumably it has the competence to restrict any right that this court is minded to introduce?
No, Your Honour, it is completely within this court's jurisdiction to make such a finding, but we simply urge this court to exercise its discretion and refrain from doing so.
Well, we're not exercising discretions. We're forming judgments as to the law. It's not an exercise of discretion.
Well, yes, Your Honor, I recognize that it is important for this court to lay down the law, especially to do justice to the parties in the case. But we say that in any event, the policy concerns that my learned friends have raised earlier, namely that there should be no taxation without the authority of the law, are not engaged on the facts today. And the reason that I make this submission is because the special charge imposed by my client on Mr. Camden should not be regarded as a tax, but instead a fee for services. Australian law has made the distinction between taxes and fees for services. Insofar as fees for services,
How can that be right? If something is a fee for a service, you get a choice as to whether you apply the service and pay the fee. There's no choice here. Surely,
Your Honor, a moment to consider the question.
right?
Your Honor, referring to the case of Air Caledonia International, this court held that the test for whether an exaction refers to fees for services or rather a tax is whether there's a discernible relationship between the services provided and the payment made. And in this case, we say that there is a direct relationship between the money paid from Mr. Camden to my client. And so, in accordance with that definition provided by this court, that there should be a discernible relationship, I say that the special charge should be regarded as a fees for services. And that,
Even though he has no choice as to, so we're going to give you this service and you're going to pay for it. But it's okay, it's a fee for service. It's not an exaction under power of office.
well, Your Honor,
Surely it must come from the point of view of the payer. That is, what am I paying this money for? And they're not paying it for council to undertake work. They're paying it because the council demands it. And they're paying it to discharge their liability to the council, but not for the provision of the services. And if there is no liability to the council, then they've got nothing for it. Isn't that how it works out?
It goes into the general fund.
And it goes into the general fund.
This is the joy of answering questions from three judges.
I really appreciate the questions, Your Honors. If I may make clear my position, the best I could do in this regard would be to refer to the explanation in the case of Air Caledonia International as to why this court found that where there's a discernible relationship, simply that amounts to a fees for services. And the court held that it's because of the discernible relationship that transforms a transaction into one which is a quid pro quo in nature. And in fact, in the case of Roy Morgan's research, the court held that an exaction made to maintain to fund the maintenance of public assets is something that is a fees for service.
In the services in the Caledonian case, were they services that had to be provided or were required to be provided, or were they services that there was a choice as to whether they got provided or not? It occurs to me there might be a difference, so that if it's part of a council's obligation to do something for the people in their district, then the fact that there's no choice might not matter. It might be that your argument can apply. But I wonder if the distinction in this case is, well, there is a choice. They don't have to do this. They're choosing to do this and force that choice on their ratepayer. How is that consideration addressed in the cases that you seek to rely on?
Well, Your Honor, perhaps in this regard, it is true that in most situations, choice might be a relevant consideration in describing a situation as one which is quid pro quo in nature or one that's commercial in nature. But we say that when dealing with a situation involving a public authority and private citizens, choice of the private citizen might not be such an appropriate factor to consider. Otherwise, it would impose a burden on the public authority to ensure that every single private citizen has agreed to the imposition, to the construction of the fees for services, to the provision of the services, and this would be in opposition to good public administration. We would say that as long as there is a collective agreement that this power is vested in the public authority and the public authority can make such demands, we say that there is a fees for services. Unless there are any further questions on this point, Your Honours, I'll quickly turn to my second submission on the doctrine of money paid under the colour of the office. Now, the framework in which we should analyse the question would be to ask whether, firstly, there is an improper pressure imposed on the private citizen, and secondly, whether such improper pressure has caused the payment from the private citizen to the public authority. This is the position taken by this court in the 1910 decision of Sagut Brothers. Now, Your Honours, where we depart from my learned friends is whether these two limbs of the analysis have been satisfied. In particular, my learned friends have referred to the power conferred upon my client by the statutes, by the Section 95 of the Local Governments Act, to say that in a situation of non-compliance, my client could register a charge over Mr. Camden's property. We say that this argument would find difficulty in the causation stage because this is the first time that this point has been raised, and it's only raised at this stage of the appeal. As we can refer to paragraph 3 of the facts, Your Honours can see that what was on Mr. Camden's mind was not any powers pursuant to Section 95, but the threat of litigation. This shows that this power was never the subject of Mr. Camden's contemplation. And the threat of litigation, Your Honours, has never been sufficient to amount to a claim under money paid under the colour of the office. Well, Your Honours,
Maybe that's where we should be developing them.
well, Your Honours, the reason that a threat of litigation is insufficient is because the private citizen always has the choice not to pay and defend the legal proceedings by relying on the unlawfulness of the demand. And if this court were to accept the suggestion that a threat of litigation is sufficient, it would be to recognize that the courts would be inappropriate avenues for adjudicating disputes because the state can weaponize the courts to compel private citizens to do their biddings. And we say that this is an untenable argument, and it certainly should not be one raised by an experienced solicitor like Mr. Camden. Your Honours, I know my time, unless I may be of any further assistance to this court.
Thank you. Thank you, Mr. Mayor.
May it please this court.
Yes. Mate. Yes, go ahead.
Your Honours, may it please this court. As introduced earlier, my name is Pandey and I too act for the respondent, the Roebuck City Council. Your Honours, I deal with two further questions that arise before this court. First, whether my client is entitled to the full defence of voluntary submission to an honours claim. And second, whether my client is entitled to the defence of good consideration. On the first question, Your Honours, we submit that the defence of voluntary submission to an honours claim is available to my client and is made out on the test. Now, on this question, my learned friend has argued that the defence of voluntary submission to an honours claim is not available for a Woolwich claim. And the key limb of my learned friend's argument has been that risk-taking is a foreign inquiry to this defence. Your Honours, we submit, and as this court had put earlier in questioning to my learned friend, that the rationale underlying this defence is twofold. First, that of risk-taking, and second, that of finality of litigation. This is a point that has been proposed by Professor Edelman, as His Honour then was, and Professor Bant in their treatise titled Unjust Enrichment in Australia at page 399. Your Honours, the crux of our submission here is that the defence of voluntary submission does find a close fit on our facts today and can apply in our dispute. My learned friend also raised the argument that this defence does not apply in our case because there is a legitimate coercive power over the citizen in this case. Your Honours, very quickly, I must note that in the rates notice, as clarified in clarification number 2 on the agreed facts, there was no consequences on the face of the rates notice. Now, if the appellant's case is bound by the argument that there was a coercive power that can be exercised on their client, this must have been adduced in the facts. The appellant has not adduced any evidence to show that non-compliance with my client's demand will lead to any criminal or penal sanctions.
Why does it have to be penal? Because threat of litigation isn't enough. Is that the hypothesis?
Exactly, Your Honour, and that is really our point, that the threat of civil litigation just cannot be enough to amount to compulsion here, and as forcefully argued by my learned senior. And what we submit here is that the defence of voluntary submission to an honest claim does find a close fit in this case. Now, a further point that I raise is that if this court were to recognise the defence of voluntary submission, it will foster an environment of good public administration where future fee payers like Mr. Camden will assess the veracity of the demand from public authorities before they oblige and before they pay. This is good for public administration. Fee payers must be able to assess the demand that they are faced with.
Is it good for public administration for government bodies to impose taxation or rates or other liabilities on the citizenry when they don't have power to do so?
It is not, Your Honours.
That's the choice, isn't it?
Yes, Your Honour, we do admit, and it is not contested today, that my client did impose a demand that was unlawful to the appellant. However, despite that,
But your client should keep it anyway.
Your Honours, we submit that my client is not keeping the money because that money has been expended to conduct drainage works.
No, you don't know that. It doesn't say that in the facts. It says it comes out of the general revenue, doesn't it?
I apologise, Your Honour.
It says it comes out of the general revenue, does it not? There's no direct relationship between the monies obtained from the ratepayers pursuant to their special demand and the expenditure, because paragraph 4 says RCC expended 300,000 from the general rates account.
Yes, Your Honour.
So that's just like from consolidated revenue.
Yes, Your Honour. I would not go so far as to submit that the exact money that was received by the appellant was then put to drainage works. But what I am sure of on the facts, and if Your Honours may refer to paragraph 5, that my client refunded $400 to the appellants, but refused to refund the rest because it had already been spent for his benefit into the drainage works.
So why did it refund the $400?
Because that was not used for the drainage works, Your Honours.
You're saying there was no legal, if there was no legal basis for it to do so, why has it done that? Is that not irresponsible government? Paying money out of its funds when there's no legitimate legal claim to it?
Well, Your Honour, we would say that that would not be an irresponsible governance. Instead, it would be a situation where my client realized after receiving detailed legal advice that the demand was unlawful. Having known that, Your Honour.
So you're accepting that government, when notified the existence of an illegal demand, would automatically ex gratia repay the money for no reason that you can identify.
Well, certainly not. We will not go so far as to suggest that it will be a general rule that government should refund the rest of the money. But as it turned out in this case, my client did, and for reasons that it did, that is not in evidence today, the rest of the money was not refunded because it had been expended into the drainage works. But in fact, Your Honours, what really is the key question before this court in this submission is whether the defence of voluntary submission is now available to my client. And we say, and the crux of our argument is that if this defence is recognised, it will foster good public administration.
Isn't your proposition, Woolwich shouldn't be recognised, but if it's recognised, an appropriate constraint on the possible downstream consequences of recognition would be the recognition of this defence as well?
Precisely so, Your Honour. Exactly. That is really what we argue today, Your Honours. And we say that this defence, that there is no objection to this defence applying to a Woolwich type claim or for monies demanded under the colour of the office. And that brings me to my second point, that even against a claim for money demanded under the colour of the office, the defence of voluntary submission to an honours claim can still be discussed. Now, on this point, my learned friend had argued earlier that if a claim for money demanded under the colour of the office is made out, there can be no voluntariness. Now, we respectfully disagree, Your Honours, because this court, in its 1992 decision of David Securities and Commonwealth Bank of Australia, had held that the term voluntary here does not refer to a situation where there is an absence of compulsion. Now, that is also supported by Professor Edelman and Professor Barnes' treatise, where the learned authors had suggested that the term voluntariness is a misnomer and it is apt to mislead. What the court is really looking at for this defence is the rationale of risk-taking and whether the payer could have contested the demand through the legal process, but has not. Now, that is the key inquiry in question. Therefore, we say that it is perfectly possible for this defence to operate even for claims for money demanded under the colour of the office. Therefore, Your Honours, we would submit that this defence is available for my client to plead, and we will show this court that this defence is made out on the test.
Why do you say that voluntariness must be measured by whether you challenge it in court or not? Why can't it be measured by whether or not you say, yes, you're entitled to it, and I agree with, I'm prepared to pay, or I don't believe you're entitled to it, but I'll pay it anyway, or in this case, it's actually not payable, but because you're a state body and I can't at this time contest it, I'm going to pay it under pressure, under protest. That seems to be a good way of showing it's not voluntary, doesn't it?
Your Honour, if I may clarify, is Your Honour's question whether essentially whether the element of compulsion should play into...
No, whether you can rightly say it's voluntary, even though the payment was made under protest.
Yes, Your Honour, we would say that the reason why we should be looking at the rationale of risk-taking here is because this defence is concerned with whether the payer has submitted to the honours claim of the defendant, the payee. And the claim here...
If you object, how do you submit it?
Your Honour, we would say that the claim here does not refer to the claim for monies, but rather the claim that my client has against the legal claim that my client has against the payer. Now, what this defence really looks at, as proposed by Professor Edelman and Professor Barnes, is whether the payer has given up its legal right, or has rather, allow me to rephrase, whether the payer has not contested this demand through the legal process after appreciating that a legal question has arisen on the facts. This perfectly describes the payer, Mr. Camden, in this case. Mr. Camden, an experienced solicitor, was almost certain, and at the first resolution, Mr. Camden even said that it is completely unlawful. Now, despite that, Mr. Camden even though he could have gone to the courts with his claim that he thought was rather strong, he did not do so. Mr. Camden assessed the merits of his claim as an experienced solicitor. He conducted a cost and benefit analysis, and he made a tactical decision to pay and not to contest the demand through the legal process. Your Honours, we say that this is precisely the situation where the defence of voluntary submission should apply and bar restitution.
What about the aspect of subjectivity versus objectivity that I raised with your opponents? On how does one assess voluntariness?
Your Honour, we are with our learned friends in that it should be assessed on a subjective basis, but we also acknowledge, as they have, that this is not made clear on the case law. But we would say that it makes sense for the courts to assess voluntariness on a subjective perspective. And
How does that work? Let's think about how that system of law would work. You've got the council, and it's exacted some money. It finds out later that it's done so unlawfully. So it asks itself, well, should I give some money back? Well, not if there's a voluntary payment. But how do they work out whether there's a voluntary payment? They've got to go and assess subjectivity, which they'll have no reference to.
Well, Your Honour, if it helps, perhaps what I really mean is that it is open for the payer to adduce evidence of whether they had subjectively submitted to the honours claim, and then it's then for this court to assess on that basis whether there was indeed voluntariness. And certainly we are not suggesting that as long as the payer says that it was not voluntary, then that should be the outcome. That is not what we suggest. And therefore, Your Honours, we submit and we maintain that the defence of voluntary submission not only applies in this case, but is also made out in favour of my client. Your Honours, in my remaining time, I will turn to my second submission.
I'm sorry
course.
to delay you further. I just had one further question, if I may. So imagine that that the court is minded to recognise a Woolwich principle, and imagine that we might also be minded that a genuine case of voluntary payment might give rise to a defence. How would you reconcile our recognition of that defence with the authority of the test claimants case in the United Kingdom, where the United Kingdom Supreme Court, I think it was, refused to recognise a defence of change of position on the basis that it would wholly undermine the policy priorities of public legality?
Yes, Your Honour, we are aware of the case of test claimants and the Revenue and Customs Commission. That is the 2015 case where the English courts have held that for the change of position defence, that defence would, in the court's words, stultify the cause of action in the first place and stultify the policy of prohibiting unlawful demands of money.
Yes, so why wouldn't the recognition of this defence do the same?
Your Honours, we would say that much to the contrary, it will promote the policy of prohibiting unlawful demands of money by public authorities. Because if this court were to place a premium on the voluntariness of the payer, future fee payers in Mr. Camden's shoes will assess the veracity of the demand before they oblige. And there is a difference, Your Honour, in this case, because
It's like saying we won't give any restitution of a mistaken payment because that will make people more careful about paying money.
well, Your Honour, perhaps at this time, it would be apt to use my learned friend's words earlier. And my learned friend suggested that it would allow the public authority to spend its way into power. Now, that is the key objection with allowing the change of position defence against a claim for money unlawfully demanded by public authorities.
I don't really understand what you mean by that proposition. Could you explain it?
Surely. Your Honours, my point simply is that a change of position defence looks at the defendant, but a voluntary submission defence places a premium on the plaintiff's voluntariness. Therefore, we would say that it would not be objectionable for this court to place a premium on the payer's voluntariness when it comes to claim for unlawful demands of money by public authorities.
Pretty brutal kind of policy assessment, though, isn't it? When one is assessing we're talking about ordinary ratepayers in this city council. how many of them act, I mean, this one, sophisticated lawyer, knows stuff, how many of them are like that? And if we decide in the way that you're saying, we're not just deciding perhaps this is a wealthy area with beautiful stuff, we're deciding for every city council, every local council in this whole country.
I appreciate that, Your Honour. And I am aware that there may be people, many people who do not appreciate the niceties of the law as we submit Mr. Camden does. Now, perhaps Justice Ormiston's holding in Hookway and Racing Victoria may assuage this court's concerns, because the court there held that restitution would be allowed in the context of the voluntary submission payment if the payment is made in ignorance of the legal position. So if there were such citizens, as Your Honour had pointed out, those citizens would be in ignorance of the legal position, and this defense of voluntary submission would not work against them. And it would work against someone like Mr. Camden in this case. Your Honours, in my remaining time, I will quickly address in my last 2 minutes the defense of good consideration. Your Honours, the crux of my case here is that the defense of good consideration is made out, and the rationale of this defense is for this court not to allow the plaintiff to be unjustly enriched in ordering restitution. Now, we do understand that in this court's holding of David Securities, the term consideration means the state of affairs existing in the payer's mind, and the court should look at the subjective basis of payment of the payer.
I think you're mixing up the cause of action for failure of consideration with the defence of good consideration, which was referred to by Lord Goffin, well, Justice Coffey then was in Barclays and Sims. The defence of good consideration has got nothing to do with the cause of action of failure of consideration. The cause of action of failure of consideration is about whether the person who's paying pays subject to some condition which is objectively manifested in the world. Defence of good consideration is about something completely different, even on your own account. On your own account, it's about whether the plaintiff has got something back and is going to be entitled to his money back and to keep what he's got.
Precisely so, Your Honour. Perhaps I may have misspoke earlier. I am dealing with the defense of good consideration as conceived in this court's decision of David Securities. And we do acknowledge that in that case, that defense was conceived in a subjective perspective of the payer. And the court will inquire as to what is the basis of payment of the payer.
And here it is to discharge liability to the council, which didn't exist, so you got nothing.
Your Honour, we would say, much to the contrary, that Mr. Camden has been conferred an incontrovertible benefit in this case. I note my time, Your Honour.
Is that the increase in value that you're referring to?
Not at all, Your Honours. And if I may just have a minute.
$30,000 worth of works, useful works done around the lake. I can understand that. I simply cannot understand the $40,000 worth of value. That seems to be entirely collateral.
Surely, Your Honours, if I just have a minute to wrap up my grateful, Your Honours. Your Honours, we do not at all make the submission that the increase in $40,000 is an incontrovertible benefit. What we suggest, however, is that Mr. Camden has saved an expense that he would be put to in the future. My client had conducted drainage works for Mr. Camden. If there were to be a flood in the region in the future, Mr. Camden would definitely have to be put to an expense if the drainage works did not exist to help with the floods. The drainage works was conducted, and therefore we say Mr. Camden has been saved a factually necessary expense, and he has been conferred an incontrovertible benefit. Therefore, Your Honours, we would say that the defence of good consideration is made out in this case. Your Honours,
Controvertible benefit, a recognised concept in Australian law?
we would say so, Your Honour, and this was recognised in the 1987 Supreme Court of New South Wales case of Monks and Poyners by Justice Young.
What do you say of the decision in Cossack, where the court expressly makes the point that no benefit is received or presumed to be received unless it is either expressly or impliedly requested? I don't see that Mr. Camden on this occasion made any request for these services to be provided.
I note my time once again, Your Honours, if I may just answer this question.
Please.
Grateful. Your Honour, we would say that in the case of Redland and Cossack, the court had held that the defence of good consideration was not made out because the basis of payment was a legal obligation rather than for their land to benefit. But in this case, we can point to as my learned senior had argued earlier, a discernible relationship between the monies paid and the service that has been provided, that is the drainage works. And that drainage works ought to be considered by this court to be an incontrovertible benefit. Your Honours, unless I could be of any further assistance,
Yes, thank you.
grateful, Your Honours, concludes my submissions.
Yes, for the appellant, who's speaking in rebuttal.
May it please the court. 1 point in reply. Our learned friends submitted that this case can be considered as a fee for service, and we submit this is an error of law for 2 reasons. First, an ultra vires demand is an ultra vires demand, and the Woolwich principle makes no distinction between whether it is a levy or fee for services, and there is no support in case law for this distinction. Second, fees for services under the Australian Constitution are only an issue of construction as to whether something falls under the taxation power of section 51(2) of the Constitution, and therefore irrelevant in this case. May it please the court.
Yeah.
May it please this court. Your Honours, Australia made a distinction between fees for services and taxes, and this parallels the distinction made by the House of Lords in the case of Climate Benson between taxes and commercial transactions. And the House of Lords held that the Woolwich rule does not apply to commercial transactions. We say that that same treatment should be given to fees for services, which this court has defined as something which is quid pro quo in nature. May it please this court.
Thank you. The court will briefly consider the matter and adjourn for a few moments.
All stand. This court is now adjourned. Now returning, please be seated.
Council, we've reached decisions on the 2 issues that we need to make decisions on. But before we announce the outcome on those 2 issues, we thought it might assist you both and you might enjoy a little bit of feedback from us. I want to congratulate all of you. I thought it was terrific. The standard was very high from each of you. In the real world of advocacy, and can I tell you, in the real world of judging, the best fun is when counsel engages and you know your stuff, the judges know the stuff, the judges expose what the problem is, you engage. Now we know that you're trying to spin us in a particular way, and you know that we're just trying to get to the right outcome. But in that intersection is what our legal system is about. And it is very rewarding in the real world. I hope that each of you has the opportunity at some stage in your professional development to do this sort of thing where it really counts, where you're acting for someone and you get the opportunity with a court, whether it's of 3 or 5 or 7, if you do get to the High Court, or even 1 in most of the other first instance cases. So I hope you got a little bit of that feeling today. I had the impression that you did, and there are aspects of it, even though we were giving you a little bit of judicial damage, that you would all have enjoyed. The only other observation, well, what observation? I don't know, this overuse of may it please the court. I mean, your counsel engaged in a case. What are we going to do? No, it doesn't please us. Go away. I just think it's a bit too much of the may it please the court from all of you, frankly. It's probably not a criticism if you can give a good answer for there to be no pause. But it is also very good to see, and you did it, Mr. Nutter, to see when a curly question is asked, a pause to think of an answer. So long as the pause doesn't drag too long, it's very good to see. I did an appeal yesterday where right at the outset, in a criminal appeal before counsel really had got to do anything more than announce his appearance. I said, well, just before we start, I want to ask you this. And he let me get out a few sentences. I was presiding, and he paused. He paused probably for about as long as you did. And he's one of the best criminal advocates in this state, and it was terrific. So I thought that was excellent. But can I say, apart from my little minor quibble about may it please the court, I thought all of you were terrific. You all engaged very well. You were challenged by each of us on various occasions, and the answers were by and large well done. So that's the comment that I wish to make.
I thought collectively and individually, you were both brilliant, confident, responsive, robust, and that's fantastic. Obviously, you've all put a vast amount of work into this, and that's so impressive. I thought the written submissions were of very high quality. Please always be careful with written submissions just to make sure they're entirely accurate. You don't want those errors to persist in writing. The only point I would make, and I know it's not really one that's suited to the present circumstances, given that you've got particular topics to discuss or to debate with the judges, is that it's often best to give up the minor point that you can't really, that is really indefensible. Just give them up. Don't be afraid to give up points. There's only in New South Wales do people argue the irrelevant points, but in the rest of the common law world, good counsel just jettison the points that aren't really going to make any difference. But congratulations to all of you.
So I can only really echo those remarks. Amazingly confident and articulate. You're all over the law. I mean, I think, of course, my interest really is in the law, and the law is tricky. And the Kozik case upon which this problem was set is itself beset with problematic misunderstandings, I think, to some extent, which I alluded at various different points about what consideration is, whether it's a defence, whether it's a cause of action. You have to navigate all of that. Then you have to marshal arguments which are responsive to what's been said in the cases, which may not be what's in the academic textbooks, because of course the law of unjust enrichment, is still gleaning acceptance all over the world, particularly here in Australia, where it's had a bit of a rough time thanks to people like Justice Derrington.
And rightly so.
He's a justice. He's a skeptic. We've got skeptics over there, believers over here. So, but it's fortunate perhaps that we don't actually have to decide the substance of the appeal. But I would just encourage you to go the way that you're going, and I thank you for a marvellous performance. It was just wonderful to watch.
Then we'll move from there to giving you the answers you want. Should we do the best team first or the individual best speaker? Anyone have a view? All right. Mr. New, congratulations. Speaking for myself, I thought that the way you dealt with the high concepts in the debate, that not that everyone else was weak in that respect. Please don't think I'm saying that, but that was I thought the differentiation from my point of view. But congratulations.
Thank you.
The choice in relation to the best team also goes to the respondent. Congratulations. It's a pity there has to be a winner and a loser, and I know it doesn't really help for the losers. Sorry about that, but we weren't being disingenuous when we said about both sides how impressed we were. We really were. I thought that both sets of written submissions were of the standard that I'd be pleased to receive on the Court of Appeal. So, although probably in a real case, it wouldn't be quite so high concept, that sort of high concept stuff really is appropriate for an ultimate appellate court. But in the court that I'm at, which is an intermediate appellate court, I would have been happy to see that sort of thing. You should have given away the footnote straight away, Mr. Martyn. But you'll know next time. Congratulations.
Congratulations to the teams. The judges didn't know this at any point, but congratulations to the winners who are Singapore Management University and also to our runners-up, the University of Sydney. So forgive the New South Wales comment, Justice Derrington didn't know.
Oh, gosh. Oh, you're in Queensland now.